I've admitted Smita now. In a minute, I'll admit the others. In a second, right?
Hi, Smita.
Hello.
Hi, Smita.
Hello. Hi. Hi, everyone.
So, hi, Smita.
Hello. Hi, Sanket. Hello, Aparna.
Hi.
Let me know when I can go live, Aparna.
We can start. Good evening, everyone. Thank you so much for joining us today. And here we are with another edition of the CalPHR ILA POSH webinar series. And it has been our constant endeavor to delve deeper into the POSH space and, unraveling newer perspectives and nuances and information. And something that I always like to say that we're dealing with human behavior here. And not to mention the law as well. There are perspectives, there are nuances, there are complications, but that's what makes it interesting. And that is how we have been able to pick up topics every month and discuss. And it's still not, there is still more to come. That's the whole, that's the beauty of this topic and the human nature that is involved. So we have two dynamic lawyers here who will discuss and debate today about intent versus impact in sexual harassment complaints. We will also talk about what the POSH Act says, and we will also see if we can talk about some challenges in when we try to implement this. So Smita, let me just take, it's my privilege to introduce Smita to you, Smita Paliwal. And I must say, I think Smita had to be there, if not in person, by name. So Smita Paliwal is an advocate and a partner at King's Tub and Kasiba, Bangalore. Her primary fields of practice include company law, labor and employment law, exchange control, general commercial transactions, and corporate litigation. She also leads the firm's division on POSH, prevention of sexual harassment at the workplace, leads workshops, clients training, and sexual harassment prevention. She has represented clients such as Swiggy, Citibank, Ashok Leyland, and Siemens, to name a few. She has appeared before several courts, including the Karnataka High Court, Pollution Control Board, the National Company Law Tribunal. She has also authored several papers and articles in various subjects, including IP law, tax law, and POSH. Welcome, Smita. It's a pleasure and an honor to have you here with us today.
Thank you, Aparna. Thank you so much.
And Sanket has more than a decade of experience as a corporate lawyer. His areas of practice include mergers and acquisitions, private equity, employment law matters, and forensic investigation in white-collar crimes. I think it deserves another session with Sanket specifically on POSH and forensics. Prior to joining Pioneer Legal, Sanket has worked for Harish Jagtiani and Associates, ARA Law and DSA Legal as part of the corporate and M&A team. In recent years, he's advised on numeric forensic investigations of suspected fraud, bribery, and misappropriation of funds, advising on fraud and anti-bribery laws in India and reporting requirements, advising on strategy, implementation of action against perpetrators of such crime, advising on preventive action and building robust mechanisms, policies to counter such crime. He is a member of the Bar Council of India, the Institute of Company Secretaries of India, and the Association of Certified Fraud Examiners. So welcome, Sanket. It's a pleasure having you here. And like I said, one more session on forensics and POSH investigations.
Absolutely.
So
Thank
you so much. Thank you for taking your time to be with us. And CalPHR is from the past 9 years, I can very confidently say that we have taken pride in simplifying things and yet keeping the legality of the subject intact. And we will try and achieve that today as well. I'm not a lawyer. I bring the human side, I guess. So we promise to all the audience today, thank you so much for joining us. And we promise an evening of perspectives and no gyan, absolutely, whatsoever. right? So Feb 2014, I did not even touch her. How can you call it sexual harassment? Cut Feb 2023, a case that I'm talking about is just a week ago. I did not try to touch her physically. Also, I did not use any vulgar words or ask any indecent question. I was just asking some questions for fun, just like how we did in college. So if you see that we have come a long way, there is awareness that has definitely gone up. They're adding layers and nuances to their intent, if I can say. But having said that, we don't see any signs of compliance or cases slowing down in any way, and many of that are about intent versus impact. And I do see that there's a constant push and pull in between intent and impact. So over to you. What do you think we can, I think, let's discuss, and if it'll be fantastic if you also share some of your live experiences, not just an interpretation or not just what the law says, but your personal experience and how you interpreted it, challenges that you faced in it. Not just what went right. It'd be great if you also share what went wrong, because I think towards the end of the session, if it's possible, if we can give some takeaway as to what should be done, what should not be done, I think that'll be nice as well. So what is intent and what is impact? Smita, can we start with you?
So Aparna, first of all, I think thank you for organizing such a debate, because every time when we see a POSH session, people would want to talk about what do you mean by complainant, what do you mean by sexual harassment. So you want to talk about from the complainant's perspective, but we cannot actually ignore what do you think about the respondent. So when you talk of intent, it can mean, if you speak of general perception, it would be mens rea, which is one of the main ingredient in a criminal matter. So you can talk from that. By intent, you can mean mens rea, but here, when it comes to POSH laws, you will not get an opportunity to prove whether there is a mens rea or not. It is presumed that if there's an act of sexual harassment has happened, there has to be a mens rea, that is, there has to be an intent. So the respondent never gets an opportunity to prove whether there was an intent or not. It is presumed, the investigation starts, that there was an intent, and then further steps takes place. So that is what I feel, that it is important that we talk about this issue as well, because everybody keeps talking about that once a complaint has been filed, the accused will definitely get into it, the accused will definitely suffer, there has to be a recommendation which would go against him. But I have seen both the sides of the coin. I have also counseled a few accused and respondents in the matters. And what I feel is that it is very important to make them aware that the act is, as generally conceived, it is not a biased legislation. At each and every step, you will get an opportunity to prove yourself, whether there was an intent or not, but you will get sufficient opportunity to prove that whether the act of sexual harassment has happened or not. So that's what I feel. It's a good platform where we are discussing.
And how about impact, Smita? What's your take on impact?
See, that's very clear. If an act of sexual harassment has happened, of course, then there is no debate about whether it constitutes sexual harassment or not. So whether there was an intent or not, whether there was the whole idea, the whole conception of mens rea was there or not, whether the accused wanted to commit that act or not, that is immaterial. If there's act of sexual harassment, if the woman feels that she has been aggrieved, if she feels that she has been harassed, then of course there is a sexual harassment.
Sanket, what according to you is intent? What is your take on it? Is it like, are we being equitable by saying that impact is more important than intent?
So I would like to kind of simplify this, go a step back and basically kind of analyze what do you mean by when you say intent, right? Intent is typically what is within the mind of the actor or the perpetrator, right? It's basically how he perceives or how he basically thinks what he's doing, what his action basically means. Whereas impact is slightly more than that. Impact is for the person who is basically the victim, how he perceives the feeling, and plus also taking into account if there are more people around, what do they perceive? So impact has a wider, I would say, weightage in that perspective. So just to simplify, it's not about whether if there was an intent, it automatically proves the crime. But if there is an impact, you cannot ignore it, and therefore it has to be tackled. That's the main issue over here. And India is a patriarchal society. We've seen the balance of power always being with the men, and therefore it's important to protect women. In fact, the legislation, the sole purpose of the legislation is to protect women, and it comes from not just Vishaka judgment or something that is just propped up suddenly. It's been a global phenomenon. There is a convention of discrimination against women, which India is also a party to, which recognizes that this is far more often that this situation does come in where there is a discrimination against women, and therefore it needs to be addressed. So although the respondent may feel that his feelings or what he did was not taken into account, I don't think so that it's correct, because over here the important fact is that the impact is so high, and the issues that come up with that impact is just something that cannot be, and you need to put an end to it.
When you said the people around, impact on the people around, something comes to my mind. I was not planned, but when you said that, it really reminded me of a case. So there was this, I had a case where these two very senior people, they were disagreeing on something related to business. And this, the lady who had to accept the proposal did not like it at all. So she was dilly-dallying. She was not giving in at all. And she was actually not even giving him time. While actually they had a good relationship earlier. I mean, whenever they visited, their respective cities, they'd go out for a drink and good relationship, good professional friendship was there. Despite that, she was dilly-dallying, and he was very upset. And they happened to meet for a common conference. And he realized, okay, this is my chance. I'm not going to leave this. And he tried to open up the topic, and she still refused, and she tried to walk away. So he caught her hand and pulled her down, made her sit down. Okay. And she still left. Okay. She still left. She didn't accept it. She didn't still, want to listen to the proposal. She also complained to the committee, to the management. But her complaint was that he cannot force me to listen to him or accept him. It was not sexual harassment. But there was a complaint to the IC by a bystander. One of the other senior leaders who were watching, he felt it looked very, very inappropriate in a work setting. It cannot be. It's something that cannot. The impact that it had on him was, he felt it was sexual in nature, and he felt a complaint. So go ahead.
So interesting you kind of raised this point. There are a couple of aspects over here. One would be the whole concept of extended workspace, right? Because you were talking about this was a conference and not actually a normal, working space. Thankfully, our law has kind of, recognized that and ensured that workplace, an environment like this, which is connected to the work, is considered as a workplace. So thankfully, if this issue was brought to an IC, you would be able to kind of at least, evaluate it. The second point which you mentioned, that as a bystander, now as a bystander, if you do not take any action, can there be, can you be pursued, or can you be, so I think it's a very important role. An inactive bystander can escalate this issue, but a bystander who actively would have taken some steps to stop this, or at least, confront this, would have made a big difference. Currently, there's nothing under the law which kind of, takes care of this directly, at least. But I think it's an important point, and needs to be addressed going forward. Of course, with this whole episode that you talked about, to a reasonable woman, or to any reasonable person, there is no question that this is sexual harassment. And to go into the intent versus impact, it's a straight answer to me again. If the intent was as naive as possible, that he was just trying to be, slightly more persuading, it does not matter if the impact to the women, where she perceived it to be, sexually, unwelcome, then that's your answer. There's your answer.
Right.
So,
Smita, what is your take on this?
For this peculiar situation which you mentioned, now here, if you look at the woman, probably she did not have any impact. So she never felt the impact. So would it come under the purview of sexual harassment is something which IC would definitely take into consideration? They like, because she never filed a complaint. It is the somebody who felt. So even if there has been intent or no intent, but if there's no impact, then there's no sexual harassment. The law is very clear on that. There have been so many cases which we also take care of. If there's no impact, so the question of whether there has been an intent or no intent would be immaterial. There has to be impact, which is if she is feeling that with this particular gesture, she she's feeling that she's not comfortable with a particular gesture, she feels that she is being sexually harassed by the person, then of course this will come under the purview of sexual harassment. But if a bystander is looking at this situation, it would be immaterial.
So, Smita, I agree with you partially on this. But if you see, if the complaint is basically raised and if the IC really kind of gets into it, and if the victim would basically say that, yes, she did feel sexually harassed, then this complaint would have actually been perceived. And like you rightly said, there is nothing for a bystander to kind of step in these case of scenarios. But an IC, once it's brought in front of them, they would typically investigate. That's the practical viewpoint.
No, that's of course, Sanket. That's what I said, that if complainant is feeling that there has a situation like that,
Correct.
and there is an act of sexual harassment, then of course IC definitely will have to investigate the matter.
Very, very interesting points. Both of you are bang on. Like that's exactly what happened in the case as well. So because there was a case raised, IC did take it up. It is an obligation for us. We did take it up. But there is no case if there is no complainant. The bystander can raise it, but the bystander cannot be the complainant. So it's not the victim. So we needed the complainant, and we reached out. She said, "No, I did not feel any. There's no sexual connotation to it at all." So we just counseled him. We had a conversation with the gentleman, and after that, the company also initiated specific training awareness programs across the board for the sales team specifically. So because their understanding of what constituted sexual harassment itself was very narrow in the understanding. Well, we have gone beyond that with the law coming in, and like the definition of what constitutes sexual harassment has become wider much earlier. So we had that conversation with them, but it was a very interesting case. And when it comes to POSH, what do you think is more pertinent in your opinion? And is it different from other laws? Like, what does the criminal law say?
See, Aparna, of course, when it comes to criminal laws, the offender needs to prove that there has been a men's day or not. So there he gets an opportunity to come and present his case. But when it comes to POSH law, it is very clear that nobody would look into the concept of intent. But see, there are many aspects to the law. If you look at the act carefully, they've also that act talks about conciliation proceedings. Mm-hmm. So I think that is something which has been introduced in the act, which is part of the act, because I think the legislation felt that there would be times where this particular concept of intent would come into. There's going to be a whole lot of debate on this, whether there was intent or not, because we come across cases where there has been a miscommunication, where there has been a misunderstanding between the parties. To give you an example, we were investigating a case where the complaint was filed, and the complainant said that she didn't like the way the accused used to shake hands. Now, shaking hands is something which is a normal way of greeting person. How do you so of course the IC was confused that how do you investigate a case where the complainant is saying she's not happy with the way the accused is shaking hands. So we got into it deeper. We counseled, of course, we counseled the complainant. She told us that the way he shakes hands makes her very uncomfortable. So we also we then spoke to her clearly about that. Is if you've spoken to someone else in the organization, have they also felt the same? So then we understood that there have been couple of witnesses and there have been several other women who also faced a similar situation and who also felt that the way the accused was shaking hands was something which they were uncomfortable with. And so some came as witnesses. They said that they have already informed the accused several times that they do not like the way he shakes hands with women. And so here, the intent plays role. So if had it been, there's only a one case where the complainant had this issue that accused is shaking hands and she's not comfortable with. And maybe that time we would have counseled the accused and we would say, see, this is something which you are doing wrong. She's not comfortable. Maybe we can have a conciliation meeting arranged. You can talk to her, you can apologize, and we can close the case. But what we realized was there have been several witnesses who came forward and said that they have already informed. So here the intent plays a very major role.
Right.
So that means his intent was to harass them, to make them uncomfortable with the way he was shaking hands. And of course, we came to the conclusion that this is an act of sexual harassment, and a proper recommendation was provided.
So just want to add a little bit of, on this similar example, which you just mentioned, let's think about it, whether if this was only a one-time thing where it happened only once, a single isolated incident where this person would have, had a handshake with this lady and she still felt the impact, where she still felt that this was inappropriate. It was a long handshake, which is not very common for her. How would you kind of, treat this? So ideally, the courts have said that, this is a subjective issue. Each case is very different. You cannot have a rule that because it has happened once and not more than once, this is not sexual harassment, right? In fact, the Delhi High Court judgment, where we've, there is a US case law which talks about the reasonable women standard. Women have a sixth sense or a seventh sense, where they are able to kind of easily pick up if there is something wrong. And you have to kind of rely on that. If the woman perceives it that this is inappropriate, you have to go by that. You cannot create a benchmark to say that this is what is inappropriate or this is what is not inappropriate.
Pankaj, I would go with you on that. Just probably to add to that, I think what's typically what we say in our training is also what's okay to me need not be okay to you at all, right? It's a completely subjective feeling. It depends on how I was brought up, my personality, my family background, or various other things that have shaped me into who I am and how I was raised, the rituals we follow, the culture that is followed at home, like if it's a wedding in North India, if there is a barat and you get hugs, you can't do that down south, right? The marriage would stop. So it's like there are a lot of subjective looking at a holistic way.
Absolutely.
And not just looking at just that act, that respect to the impact that has been created. I think that is what the law talks about. And it's not, the idea is not to discriminate against the accused. And I think there is enough and more opportunity for the respondent to be able to defend himself or herself. So
correct. You're so right. With India, we have like so many cultures, so many different, stratas of society that we kind of, everybody encompassed into one. It's really difficult to kind of set one sort of a common benchmark. And therefore, the facts in every case would be, what would play a role in deciding whether a charge of sexual harassment is there or not. Just to add to that, it's one more thing which kind of keeps on coming up is in these cases, is it just men versus women or women versus women also? This is also something which has been kind of propping up.
In fact, fact, Sanket, there has been a ruling by Kolkata High Court, I think about 6-7 months back, where they said that accused or the respondent can be a woman.
Right.
So basically, the complainant will always be an aggrieved woman, but the respondent can be the male or the woman. Anyone can be respondent.
Right.
I think that's a good breakthrough in the law.
Absolutely.
Which I feel.
Correct.
Can you say, for the benefit of our viewers, you can say the Cook case law, please? Amulya can put it in the chat.
Aparna, I don't have the citation, but I can definitely send it.
Just we can share it with them later. Amulya, you can just make a note if you can share it. It may be useful for people. So there's one, Sanket, you did mention sometime back about I think Smita, you said about the decision that comes out of a sexual harassment inquiry. When there is a complaint, there is a case going on, there is still a thought that it will result in termination or something that's going to be very serious. Everybody is going to get to know. And so having said, with that in mind, if you look at impact and intent, with intent and impact, can you help us understand how the decision is being, how these two play an important role, if I can say that, and I would like to know your views on that and specific inputs on that for our audience.
So, Aparna, whenever we come across cases where the accused keeps on harping on the fact that there have been no intent on his side, but a complainant has filed a complaint, and of course, when if she has filed a complaint, IC has to take into consideration, and she states that there has been an act of sexual harassment. So in those cases, when we feel that there has been a miscommunication, because IC will look at both the statements from the complainant and the respondent, and then if they are of the opinion that there is a case of miscommunication or misunderstanding, they would go to complainant and they would say that would you be open for a conciliation proceeding? If she says yes, but one thing you need to be clear of is that you cannot force the conciliation on the complainant. She has to be on consensus. She has to provide consensus to it. And in those cases, we can just ask the respondent to clear out the misunderstanding. He or she can apologize to the complainant, and IC can close the case. If at all this conciliation proceedings, because the Act has clearly stated that this is something which can be tried. So the cases where the accused is of the stand that there has been no there has been no intent on his end, IC can take this provision section 10 into consideration and can think about conciliation. In fact, we came across a case where one of the allegations was there was an event organized by a company, and the accused had given certain compliments to the complainant, which she didn't like. However, the interesting thing was she did not tell the IC what were those compliments. She didn't remember. However, she said that she did not like it, and she did not like the gesture of the accused, the way he complimented her. So we went back to the respondent, asked him what were the compliments. It's like it was a general compliment, and I don't see anything wrong with that. She looked nice, and I just told her that you look really beautiful today. So we went to the complaint, say that maybe there's a misunderstanding. He says that there was no intent of sexual harassment at his end. But since you feel that you have been harassed, if we can explore a possibility of conciliation where he can come apologize to you. So she agreed to it, and then of course IC suggested conciliation. There was a meeting, both the party reconciled, and we closed the report. So there we can say that you cannot completely ignore the aspect of intent. Of course, you would have to investigate the matter because there's an act of sexual harassment. But for cases where there's no intent, probably you can look at conciliation. And the kind of recommendation which comes from IC could be in the form of maybe the accused should be sensitized about the matter, because in such cases, what we feel is there's not been proper training or workshops not being held in the organizations. So I feel at some part, I think the company's organizations are also responsible. If there has been acts where the accused is time and again taking the stand that there has not been an intent.
Sanket?
Yeah.
And there's some conversation, parallel conversation going on in the chat window. So I think one of the comments was that it depends on the gravity of the harassment, gravity of the impact or gravity of the incident would play a role as well on this decision. Let's conciliation. The IC themselves might not be willing to go ahead and propose the possibility of a conciliation if the incident, if it is not as simple as what you described now, Smita, right? So,
Yeah.
So I think Sanket, what would
Sure.
share
So
your
just,
thoughts?
so from my perspective, typically the way I look at it is intent versus impact also becomes critical when you are kind of, giving a recommendation from a IC perspective.
Right.
Because
Yes.
that helps you kind of understand what has happened, and then, kind of the degree of punishment can be decided. If it's a one-time thing, which is, not something which is that critical, a handshake probably, so in such a situation, you basically just kind of sensitize the person, explain him more awareness. So those things can resolve it. But if it's, so I think the punishment basically to decide a particular punishment becomes slightly easier once you know the intent and the impact. On conciliation, again, I would, this is kind of slightly lost, but typically it should be the victim who should be requesting for a conciliation. It cannot be the respondent who kind of requests for a conciliation. Can never be the case.
Right.
If the victim is comfortable because the victim has kind of faced, the victim can decide, but it can never be the complainant who proposes conciliation. And plus, because there is no scope for any monetary settlement, that also should be kind of, kept in mind, because conciliation proceeding is just to kind of ensure that the, issue is resolved, awareness is created, relevant people are sensitized, and, you move forward.
Right. Conciliation, it's just, we just make the parties aware that there is an option. But where I was coming from is that if the allegation itself is so grave, then we may not, even if, there has been situations where typically it has happened more with two people are in a relationship and the relationship has gone sour, and now that the complainant is scared, so she comes and complains afterward. But as we start in inquiry, they start, there is this fear. They realize that, okay, this is not going well. I think he's going to get fired. So the minute they hear, when they see that, they understand it is not just what has impacted them. It is also going to impact his career, or probably life on the long run. They immediately kind of pull back and they want to go in for conciliation. But if you look at, in some of these situations, we did not want to. While I understand that the complainant holds the key, she decides if it's conciliation or not. But the act was so grave that they had actually, the specific incident was that they had made up inside within the office premises multiple times, and they also in the beginning of on the case, both of them were lying at various points in time, and he had gate crashed her home. So it's like trespassing another employee. It doesn't matter if they were in a relationship or not. It is an employee. As far as the company was concerned, it was they were employees and they were trespassing. So given this situation, the company took the IC was not willing to go through a conciliation. I know it's slightly deviating from the topic, but then when it comes to it's kind of connected, so I just thought I'll bring it up. So the decision always is not towards.
Correct. In most cases, typically you'll see that the resignation letter is immediately put up as soon as there is a complaint that is filed, right? So the IC is led toothless, and in this he said, she said situation, typically it's a disaster. So
that's true.
The impact, intent and impact is just anybody's say in that case.
So I think, from a process perspective and from a justice perspective, are we this stand of that the impact is more important and intent doesn't matter? are we being equitable to the respondent? And how can we ensure that we are being fair?
Aparna, of course, because the law is very clear that you need to give equal opportunities to both the sides. Even in this L.S. Shibu case of Kerala High Court, they specifically mentioned that fairness, what do you mean by that principles of natural justice be complied with, is that fairness should be there in the proceedings. So what we mean by fairness is that you need to hear the respondent. If he's saying there's no intent, that's okay. But that is something we have to investigate and find out whether their act of sexual harassment has happened or not. Knowingly, unknowingly, but if the act of sexual harassment has happened, if the evidences show that there has been an act, then appropriate recommendation has to be given. Recommendation can differ, of course, because where the party you have been able to prove that the respondent was actually not aware of it, there you would go with this recommendation of that appropriate training should be given, or he should be warned,
right,
or he should be part of certain workshops that we, a lot of times we end up giving this kind of recommendation where we feel actually the person was not aware of it. So there also we on the report would say that there has been an act of sexual harassment being committed.
Correct.
The gravity of recommendation would differ. Definitely.
Only the gravity, depending on the intention, the gravity would differ. Doesn't mean
yes,
it's a complete excuse. So some questions are coming up. We will open it up for question right away, right after Sankit shares his opinion. We'll open up for questions.
So I agree with Smita on this last point. Typically this is how it would be ideally, play out. Challenges that we typically face is that, for having an impartial inquiry, the committee has to be kind of equipped with the right skill set, right? The biggest challenge that we face is that ICs that are constituted, because these are employees working in an establishment, are not aware about the law. They don't know what process to follow. What is the correct process? What is how to handle documentation, confidentiality, all of that is that new for them, right? So I believe that becomes the biggest challenge, which, I think judiciary needs to kind of think about how to kind of tackle it. Although they've given provisions like an external member, you'll hardly see committees, which are correctly formulated. Look at the recent example of Wrestling Federation of India. They have a committee where the chairperson is a man and not a woman. It's not rightly constituted. So look at, it's such a prestigious association, organization, and they don't have a correct IC. They don't even actually have an IC committee. It's an ethics committee that they are relying on for this investigation.
The larger they are, the harder they fall. Sometimes it makes me think like that. So Sankit, since we have brought up the process and we are talking about fairness, we are talking about giving a fair chance for the respondent to defend himself, I would request you to just lay down the process in a easy to understand way for the audience, so that they can make notes. So, but I must say that we have always insisted, and there is a set of step-by-step process we follow. And when I started my POSH career, I remember my mentor used to say that, imagine yourself as a judge. I don't know if it is right or wrong, but I liked it. So it just stuck with me, And I remember one of the IC members from my in a client organization used to say, I wanted to be a lawyer, but my father didn't allow me. I'm happy now. I'm an IC. Now I'm not a lawyer. I'm actually a judge. So I remember the glow in the face. It's something that I will never forget. So Sankit, can I request you to put down the process?
So typically the complaint should be filed within 3 months time period. If an extended period is required, there have to be valid reasons. If the incident is a repeating incident from the last incident, 3 months, you can file a complaint. As soon as the complaint is typically filed, it needs to be sent to the respondent within 7 days for them to look at it. And the respondent then needs to file a reply within 10 working days. Once the reply has been received, the inquiry can commence. There is no set process as to timelines as to what should be done, because you have the the complaint, you have the response to it, and then the IC can basically decide how it wants to kind of go ahead. The only criteria is that you need to kind of finish the inquiry within 90 days and provide your recommendations. Once the recommendations are provided, the employer has an opportunity to kind of give its comments within 60 days. And post that, there is a 90-day period to appeal, basically.
So the only thing I want to add here to what Sanket said is that in terms of fairness, because the committee follows principles of natural justice, the documents or whatever, it's a completely transparent proceeding. And the respondent gets an opportunity to defend himself or herself. So that's possible because you see everything, or you see all the documents that has been submitted, the evidence that has been evidence that has been examined, or the testimony is given. So,
right.
So that is where the process brings in fairness, and I think it's amazing. So
just want to add to it that there cannot be an anonymous complaint. There has to be IC will only add to it, or if there's a complaint with a name. So that is one of the key aspects that I feel, which shows that there has been a fairness, which IC will definitely take into consideration, and they would act on the complaint in a very fair, and they would follow the principles of natural justice.
Yeah, and just to add to that, there's also a counterbalance. If there is a frivolous complaint, there is punishment for that as well. So, it kind of balances that. Nobody will basically then want to file a frivolous complaint, right? And the incident has to be explained properly. It cannot be a vague incident. So I think in that way, the is pretty balanced.
Correct. Absolutely. So the floor is open for questions. I'll start with the ones that has been put up in the chat box. Rashi is asking if is there any recommendation list on what is fair recommendation for what act? Because we have been saying that depending on the gravity of the incident, there could be the decision would change. So this question has come up. There was once a question by a senior leader who decided what is appropriate. Who decided what is appropriate? Is it purely IC judgment or some reference point in the act?
See, recommendation would be based on the service rules of the company. So whatever organization will have service rules. But I said that if I see the opinion that as I said, that if they feel that there was no intent or the gravity is not that great, then they can suggest a simple warning be issued, or a training or workshop be arranged for the respondent to participate, so that he can be made aware of the provisions of the act. But recommendation would solely be basis the service rules.
And also the severity of the act kind of decides whether, it's just a warning, counseling, or whether it results in a termination or compensation also. So again, there is no tests or principles that we have right now. It's basis, what the rules have kind of articulated. But again, the rules will not go into the every scenario. So again, there is scope of subjectivity. It's to the discretion in that sense of the IC to then kind of decide basis what they have looked at.
So one thing I want to add is that the decision has to be proportional to the act committed. It cannot be, let's say, for example, if somebody made a comment, let's say, in the case that Smita was just talking about, saying, "You're looking very beautiful today." And maybe the lady didn't like, maybe the complainant didn't like it. That's fine, fair enough. But then for this, you cannot say, I'm going to fire this person or I'm going to suspend them for 10 days. So it has to be proportional. Rashi, to answer your question, I think both of them are saying there is no particular, you are guided. The decision is definitely guided by the service rules of the organization. And that is why we insist that when we do audits, we insist that even the returns nowadays have started asking that there has to be a misconduct under the service rules has to include sexual harassment, and there has to be specifics. You have to go into details, as much details as you can provide. Then your service rules of the organization becomes the guiding point. Otherwise, it goes with the gravity of the situation. Whatever is proportional to the act committed, the IC would go with that. And there is fairness there because it is not one person who's deciding. There'll be multiple, the senior people, like at least 3-4 senior people. You have an external member coming in, bringing in an external, experience from other cases outside. So based on that, the committee has to decide. One more question. Is men are men only come under men's? What about people under LGBTQ? Okay, there's a question about. So I think there was a Suresh Mensria has a different meaning, and Amulya has put it in the chat. But the other part of the question: what about people under LGBTQ? Are they also covered?
So Aparna, right now we do not have any case laws where the judiciary has taken into consideration whether how do we cover LGBTQ community there. But there has been, as I mentioned, there has been a judgment passed by the Kolkata High Court, which is there in the chat as well, Malavika
Yes.
Bhattacharjee versus IC committee, Vivekananda College. They have mentioned that respondent, even a woman, can come under the category of respondent. So a complaint can be filed against a woman also, not just men. However, if in case there is a situation where a person from LGBT community is facing sexual harassment, then you cannot come under POSH, but you can go to anti-harassment policies of the organization. So there you have a chance where your grievance can be redressed.
Correct. Same thing even for men, right? Like today, currently, there's no POSH does not cover them, but there are more and more corporates which are actually recognizing this and adding this to their policy that if even sexual harassment is where a man is a victim, that should be kind of addressed. So it will depend on the policies of the company, but there's nothing in the law.
Any person who identifies herself as a woman is covered by under the act, right? I mean, it's not a trans person, a trans woman who identifies herself as a woman is covered under the act, right?
So we've not seen any such situation being challenged, right? So
yes, but woman, if the definition of complainant is ugly woman, so if he or she identifies herself as a woman, I think POSH can be, you can say that they can fall under the category of POSH. If on papers you're a woman, then I don't see any issue why IC cannot consider such a complaint.
So Neha has a question about conciliation. Can the IC issue a conciliation return warning? Because there are terms of conciliation which is agreed between both the parties, but also adding to that, can the IC recommend a return warning or some punishment? Yeah, so IC definitely can recommend written warning. The only thing, IC will not be issuing it. IC will be recommending it to the management. They can issue a written warning. Okay. Sanket, is that what you would also want? Any perspective?
Yeah, I concur with that. There's no much, because the IC can recommend. There's no two ways about it. But typically in a conciliation, when all matters are resolved, then the IC also, practically kind of steps away, because the parties have resolved. And in those discussions, typically, all of this is kind of taken into account. So
in part of the earlier discussion, there was a question little earlier in the chat box that if the impact isn't felt, but the bystander feels that the behavior was odd for a work environment, isn't it the concern of the disciplinary committee to handle? So does it go to the disciplinary committee because there is no complaint? For example, in the case that I was sharing, would it go to the disciplinary committee?
Yes, it will. Like you rightly said, even in this case, it happened, right? So any complaint that comes in will be looked at by the IC, but if there is no formal complaint by the agreed person, then the matter will have to be dropped, right? There has to be a complaint eventually by the victim.
Yeah, so maybe IC, of course, IC cannot take up the issue, but it can definitely go to the discipline committee or covered into the anti-bullying or anti-harassment policy of the organization.
I have a question, Aparna, if I may.
Yes, Madhavi, please.
There are two questions here. So hi to the panelists and thank you for sharing your valuable inputs on the topic. My questions are, number one is, conciliation is an option given to the complainant so that she can come forward all by herself without any coercion. But in case the gravity of the complaint is such that is on the spectrum of severity of the offense, if the IC has understood that this is indeed a very severe offense and is probably so severe that conciliation should not be taken up, though the complainant is willing to, then can the IC guide the complainant, saying that I'm sorry, but you cannot go for conciliation because the nature of the offense or the severity of the offense is such that if you go for conciliation, it sets a very wrong precedence that the IC of the company is taking such severe matters quite lightly. Now, the complainant might be under the pressure, a number of pressures which we come across, why they go for conciliation. But can IC take this as a, take a lead and say that by ye conciliation ho nahi sakta, because it is a very severe offense. Can you throw light on it?
Hi, Madhvi. So Madhvi, the idea of conciliation is that you cannot force it, nor IC can so moto go ahead with it. So if the complainant is not ready to, if the complainant wants to go for a conciliation, we can definitely, IC can definitely counsel the complainant. They can speak to her, make her understand that she should pursue the complainant, complaint. They are, they are going to investigate the matter. They will also, they'll try to counsel and to figure out what is making her to take this stand. But if in case she insists on conciliation, then IC cannot so moto investigate the complaint, because the act is very clear that you need to be fair. And if the complainant is not coming forward to investigate the matter, then the investigation cannot continue.
Okay. My second question is that as an
I just want to add to what
Yes.
Smita said, Madhvi, just to take to completion. So I've had multiple cases with similar situation. So the IC and as an organization, they were not willing to put this matter to rest. But the complainant or the victim was not willing to press charges, not even conciliation, forget conciliation, not even willing to press charges. Then the company, so the IC actually ended up passing it on to HR to be taken up under the code of conduct of the organization. IC doesn't have jurisdiction anymore. IC will not be able to take it up because the complainant, the victim, is not there to doesn't want to go through this inquiry. In another case, it was a conciliation, but the company was not willing to let go, and they took it up in the case where there was no complaint at all. The company took it up under the code of conduct.
Okay,
So
that's a nice way of setting a standard, because such things can't be accepted. To create,
correct, but it also, there's a complication to that. There is like there cannot be a case of double jeopardy where you cannot punish the person for the same offense twice. It has to be dealt on case to case basis, based on careful evaluation of the situation of the matter involved is what I would say. Sanket, anything from you on this?
Just the victim's judgment on this has to be kind of trusted, right? You cannot challenge that. If it's the victim who's gone through everything, and if for whatever reasons, I think one thing which the IC can check if there's any coercion or something of that sort, but nothing beyond that. The IC needs to know when it needs to stop. So
right.
it's very clear.
Makes sense.
The second question which I had was that when we have IC in place, we all know that IC is competent enough to handle these kind of cases. But the question comes that the victim has to be a woman. But in the other scenarios where the victim is not a woman and any other LGBT community or a man, whatever, whichever other genders we can, then though the jurisdiction of IC is restricted from the Act's perspective, can a company make a policy that it gives an additional role to the same team of IC where it is handled, but the recommendations do not form a part of the process which comes within the scope or within the power of the Act? Is that flexibility available, or you need to have a separate committee? Maybe the members can repeat, but IC nomenclature cannot operate. Is that the right way of doing it?
Madhvi, in fact, that is true. A lot of organizations they will have their inquiry committees, not just IC, but to take care of matters which are not under the purview of POSH. So definitely it will not fall under the POSH. So all the obligations which are there under POSH, they don't have to meet up with. But you can have organization can have a separate committee, investigation committee or ethics committee who can look into these complaints and take action.
All right. Thank you so much. Thank you.
Hello, everyone. Myself, Astak. I have a few questions. Can I ask with the panel
Yeah,
members?
please.
Thank you, ma'am. Thank you, everyone who is providing this awareness to us. So I have a questions. Like, if it will be considered as a sexual harassment, if it is done outside the working hours or some other event, but which is a company event, so can it will be considered?
Asa, it would be considered. I've written a paper on it that's called notional extension of workplace. So under labor laws, they have the concept of notional extension. So which means it's not just your workplace, that is your office, but wherever you are going or wherever you are visiting the places outside your premises and you are carrying the duties of as an employee, that could fall under the category of your workplace. So if you are attending an event as an employee of the company, that would be also your workplace. So if an incident like that happen, IC can definitely take this complaint. So it's just not your office boundaries. Any place we are visiting as an employee, you can that is considered to be your workplace.
So the act,
Okay.
Asta, just to kind of
Yes, Ankita.
the act itself recognizes this. It's not by extension of some precedence. The act recognizes this. Challenge is when we are talking about an outside workplace, which has to be then kind of said that's a deemed workplace. There are various permutation combinations that are possible. So with the facts, one can then determine whether it's linked to your work or not. So, for example, if you're in your office and you take somebody out for a coffee, or you met somebody outside the office, your same office colleague, and when you ask that person to kind of, okay, let's go for a coffee, does that get covered under workplace or not? Given that your association with that person is because of working together, it will still be considered as a workplace. So there are various permutation. Of course, these are not being tested by courts, but ICs kind of look at it from a conservative perspective that since the relationship is out of a working relationship, this still could be considered as a workplace.
So in fact, I'll give you an example. Asta, it also depends on the IC of that particular organization. Some organizations are very strict on that, whether there has been an act of sexual harassment committed by the employee, they would take it into consideration. In fact, a couple of months back on LinkedIn, there was one woman who actually there's one of the e-commerce companies were involved, employee of the e-commerce company. So she put it on LinkedIn that she's been stalked by that particular employee of the company. And their IC took that into consideration. They wrote back. There was a chain of trails of messages on LinkedIn where they acknowledged it. They said that this is our IC committee. You please file a complaint. We'll look into it. So it also depends on how your IC is taking care of. Some will have a broader perspective. Some will have a narrow perspective. But still, it's not. If you feel that IC is not taking care of it, you also have an option. There's a she-box now. The portal is there, Government of India portal. You can also lodge a complaint over there. So then they will write to the IC of the organization and they will have to look into the matter.
Okay, thank you everyone. And I have one more question. Like, is there any minimum like committee members requirement to form the ICBC? In committee members, like it should be.
So minimum is 4.
But to be in a committee. Yes, sir.
Minimum is 4, Asta. 4 members. One is the presiding officer has to be a senior woman employee, and there has to be an external member, and then 2 more members. 4 is minimum. Anything more than that, it depends on it's the company's wish and depending on the size of the organization.
In this 4 member, ma'am, in this 4 member, external member is mandatory, right?
Mandatory. 4 is mandatory.
So our advice is to have an odd number so that the decision making becomes easier. So that's generally been our advice, at least.
I have one last question.
I have a question to Sangeet.
I think can I request Girijesh to go first? I mean, I think he has been raising his hand. Then we'll come to Madhavi and then to Sundar and then we'll wind up. Yeah, Girijesh, please. Mr. Gupta.
Yes, ma'am.
Yeah.
So,
yes.
I have actually many times I come across sometimes these types of problems. Like my company who has branches in each state. So, and they have more than 10 employees in each state. So suppose we have 100 branches across the country. So shall I, by law, I need to form 100 IC across the country? Or can we have, by law, can be permitted to form a centralized IC constitution? Because in case if I form 100 IC, then we need to file return for 100 IC. If we can have one centralized IC, then we can do it, at the end of the year, we need to file a return as well. Na? So this is the problem. Sometimes what happens, at many of the branches, we don't have a senior female member. So can we, this is the again one problem. Because since we don't have any female senior employee, so to maintain the 50-50% ratio for male and female, this is the again new challenge. So many times we are not able to form our IC by law. We have to recruit, means since we don't have the female otherwise, or if law provides us to form, to have to consider a female employee from other organization, then we can do it. But I don't think it is by law permitted. So these are two aspects. Can we have a centralized IC for more than one locations? And second one, in case we don't have senior female member, then what?
So Girijesh, a very important question. In fact, this keeps on coming up quite often. So the way the law is provided, it requires you to have at each location. So let's start with that. I understand your concern, given the number of locations, just impossible. And it's impossible because, like you rightly said, at each location, you might not have those many number of women, right? So how do you do this? The midway, as you suggested, to have a centralized committee, I would not kind of advise that. What you could do is have clusters. You have smaller regions, say in the south, where you have a small pocket where you say that, okay, a couple of your offices are there, and have a committee for that region. Why the law says this is because to have a centralized committee, the centralized committee would not be able to appreciate issues of various locations. Every location has its own challenges. And to have a centralized committee will not be able to solve the problem for each and every location. So therefore, my suggestion would be kind of have regional ICs instead of having a centralized committee. But wherever possible, if a location permits where there are enough number of women, try and have those committees for those locations. Hopefully the law will develop and we'll have some clarification soon. But as of at present, this is the requirement.
Thank you. Thank you, sir. Thank you, sir.
Aparna, yeah. So my question is about the 3 years term. Now the Act says that the members have to be reappointed, or the committee has to be renewed. That applies to the external member also, because there's no specific thing told that it's only for the internal members. Is there any case law dealing with this kind of a membership related matter? Because what happens is, my observation is that a client has got used to a particular member as a POSH trainer. And because of the nature of this topic, or whatever this sensitive topics, the external member gets to know a lot of things, confidential matters of a company. Now, the client is not interested in changing the member, external member, every 3 years, because a lot of sensitive, confidential matters get disclosed. So we would wish to have the same person for a longer run is their take, but the law doesn't allow. Is there any case law dealing with this kind of a question, this area of question?
So Madhvi, again, interesting, point, there's been a lot of discussion on this. I am not personally aware about any case law on this subject. As we see it, we recommend that this rotation should happen. What typically happens is that these external members, they have sort of a community, and so we kind of replace those same individuals within the group, but there is no way to kind of continue with the same person, at least as of right now.
Okay.
Sanket, can I correct it?
Yes.
Yeah, there is a case law which appeared almost a year back. In the event of a competent person not being available, the 3-year time period can be extended for with the existing members. But that has been noted in the formation of
Notified.
the IC and communicated. So
Right.
I myself have extended several people wherein the competent person, knowledgeable, or people with interest are not available. It is there. There is a case law. I can send that to Kelpetsar.
Okay, could you please share it?
I had come in one of them.
Thank you, Sundar, for enlightening me as well
Okay.
on this point.
So,
Just
Aparna, can we expect that case law from your end? Some
Sure.
information?
I will.
Sure.
I will send it to Kelpechar. It had
So
come in one
we-
of the discussions itself.
correct.
Definitely.
Just to add to that, when you say this, so I am aware about this position at least, but in Mumbai, like a city like Bombay, if you make such an application, the officers typically do not accept it. That becomes an issue because in a city like Mumbai, to say that you do not have any other person just does not go right. So it does take some level of questioning.
No, sometimes what happens is maybe the government machinery or the concerned people are not aware about the law, and they are just forcing the authority, which we have seen hardly of in this law. I have seen is only 3 or 4 states who are really interested in doing it because the concerned district officer is keen. Otherwise, everywhere the law is simply sleeping.
Right.
That is true. That's true. That's true, Sundar. I would agree to that. If there is that specific DO is interested and they are looking into it, then they take and they take interest. So that so Shraddha had asked before some time that if the punishment does it get documented, does it get passed on to future companies? So that happens only if there is a background, if the allegation was proven and the decision or the recommendation has gone into the personal file, and if there is a background verification that comes in, Shraddha, to answer your question, if you're still here, then they may get to know that there was a case. Otherwise, if it is a termination, then of course the termination, if it is a termination, then the termination letter will say that he has been terminated due to these reasons. Then naturally it becomes an issue. That is why companies are very hesitant. It's not very every other time that companies take the decision of terminating people. They may ask them to leave many times. I'm not going into the discussion of right or wrong. I'm just saying that is what many companies do because they do not want to spoil the person's life. For that reason, for humanitarian reasons, companies do not terminate people for that reason. But sometimes if the offense committed is so severe, then some companies do take that decision as well. I think we should wind up. It's 5:07 and people, we had only asked for 1 hour's time from Pradhan, Sanket, and respecting all of your time. I'll just quickly sum up. Yes,
okay.
yes.
Okay. First, I will shoot the question to the panel members. In the event of a general neutral policy existing, if there is a sexual harassment complaint made by a male, in my opinion, it will not fall within the Sexual Harassment of Women at Workplace PPR Act 2030. It has to be dealt as per the service rules and not as per this act. So I want panel to explain this. And secondly, punishment of one company should not be shared to the other company anywhere, even in any profile, because it violates confidentiality.
So I believe on the first point we just mentioned, we've discussed that that this act does not deal with sexual harassment against men. So I believe there is consensus there. I don't think there is any.
Yes, there is. Yeah, there is consensus. Gender neutral policy is something that companies are wanting to follow, but can it be treated as a POSH case under the IC? The answer is no. There are many points like, the quasi-judicial body or the power of a civil court having an external member. None of this would actually be applicable in that case. So it may be the same committee by maybe a special ruling of the organization, but it will be dealt with under the service rules of the organization only, not under the IC. I think there is consensus here. We're not saying anything differently, Sundar. So the other part on the confidentiality, Smita, Sanket, you want to take it?
Sure. So again, typically what IC members follow, or even an external member follows, is that they don't disclose the facts of what the punishment was for what case. They typically just give examples that this is the kind of punishment that they've seen in other organizations, and that's how it's spoken about. I don't think anybody discloses the names, details, facts, etc., etc. So
Absolutely.
Mr. Sundar, recommendation anyways goes to the management. It is never discussed with anyone else in the organization. So only IC members would be aware of the recommendation, and management, that is key persons, would be taking action. Only they would be aware. Rest, all the proceedings are confidential.
So I think he's asking that question because I said if somebody, there is a background verification and if there is a question. So Sundar, I think Sanket has answered your question. No specifics is ever shared even with
then fine.
Even there is a background verification to the agency.
I just want to share one experience. When I was training some of the Indian women placed in South Africa, an Indian team, and I was doing a virtual training on POSH. I had a question from South African dad telling, in South Africa, we have a law which is sexual harassment. It doesn't call sexual harassment of women at workplace. So in our country, if a woman who is also harassing men for such things, she is liable to be dealt according to that law. So I said, as far as Indian law is concerned, it specifically says sexual harassment of women at workplace. In that being the case, in the event if you find any of our women involved in that, you take as action as per the local law. So ours is very specific to Indian connotation and Indian women working there, and the responsibility of the account manager who is there dealing with the Indian crowd.
Thank you, Sundar. So I'll just quickly summarize in a quick minute, and I think we can wind up. So the POSH Act of 2013 definitely very clearly says that impact is more important and not intent. But it is important to know that the examination of intent should not be used as a reason to justify harassment. I think all of us are in agreement with there. Even if behavior was not intended to be harassing, if it has had a harmful effect, if it has had an impact on the recipient, then it will be considered sexual harassment, even if it is just one incident. Even though that says even a single incident could constitute could be called a sexual harassment incident, if depending on the nature. The decision is something that gets impacted by the intent and impact. If there is a case inquiry and there is if there was no intent at all, then the decision, the verdict of the recommendation of the committee would be correspondingly, proportionally would come down. And also generally speaking, also the decision of the recommendations of the committee is should be proportional to the offense committed. So the current approach of impact taking precedence over impact helps to ensure that the victims are taken seriously and that their experiences are validated. But it is also important to ensure that the respondent, or we don't use the word accused. So for a better choice of want of word, I'm saying accused individuals, they're also treated fairly, and under the principles of natural justice, they get an opportunity to defend themselves and their rights are protected. That is something we have to keep in mind when you're handling sexual harassment complaints. So I think that's what this committee, that's what this panel spoke about today. Thank you, everyone. Thank you so much for being patient, and we had some fantastic questions. And thank you so much, Smita. Thank you, Sanket. I enjoyed this conversation, and thank you all for your time. Have a very good evening.
Thank you, Aparna. Likewise.
Thank you.
Have a great day.
Thanks. You too. Bye-bye.
Thank you all. Thank you.
Thank you all.
Thank you, everyone.